Hi, this is attorney Mike Keating, and today we're going to talk about the legal doctrine of open and obvious. While most of the cases that we handle for injured bicyclists involve a collision between the bicyclist and the driver of a motor vehicle, there's another type of case that we handled called the premises liability case. In a premises liability case, we're arguing that our bicyclist was injured because they hit some sort of defect on the roadway that led to them crashing and getting injured. Now, when we have a case like that, we're arguing that something like a pothole where the city, the county, or the state was responsible for it and they didn't repair it, or we have a situation where there's a construction company responsible for the maintenance or the repair of an area and they left something in the area or didn't correctly fix it. We're arguing that those entities are responsible for the defect that was left and led to the bicyclist's injuries. Now, in those cases, the attorneys for the construction company or for the municipality that own the roadway, they typically will argue that the defect was actually what is known as open and obvious. And what open and obvious is, in many ways, is what it sounds like. It's the idea that this defect was so out in the open and it was so obvious to anybody looking at it that a reasonable person would have tried to avoid or stop in front of this defect and the crash never would have happened. In other words, they're trying to say to the bicyclist, it's on you for not going around this defect. Now, in these situations, what we then have to do is prove that this defect was not open and obvious. It's usually very easy for us to show what the defect was with photographs. However, each case is very, very different. Different potholes are different sizes, depths, there's different coloration between the roadway and the pothole. Same with each kind of construction defect. They can all be different. So each case gets very, very fact-specific and very granular. In a recent case that involved a defect on the Halsted Street bike lane, there was what we call a vertical delineation, a height difference that was left in the Halsted Street bike lane during a resurfacing project. In that instance, we took a Coke can, and the reason we used a Coke can is it's iconic. Everybody knows the height, the width, the general dimensions of it. And we used that Coke can in photographs to demonstrate the height differential between the lower part and the higher part and how it was much bigger than it seemed to the naked eye. And the reason was because to the naked eye, since this defect between the higher part and the lower part was patched with asphalt and it was all the same color, that a bicyclist moving along and looking for pedestrians and other bicyclists and motor vehicles wouldn't easily be able to see it. In that case, once we were able to show that this was not an open and obvious condition, and just about anybody would have crashed here and fallen like our bicyclist did, we were able to push the liability onto the part of the construction companies. We then were able to enter into settlement negotiations with the judge at the Circuit Court of Cook County and successfully resolve the case. If you have any questions about personal injury law or this issue, feel free to contact us. You can find us at keatinglegal.com or here at illinoisbicyclelaw.com. Thanks and ride safe.